Hi, thank you everybody who has jumped on, or if you're going to watch the replay. Before we get started, I just want to acknowledge that I am hosting this training from the lands of the Tarabalung Bunda people, and I want to acknowledge the traditional custodians of the lands on which each of you are living, learning, and working from today. I pay my respects to elders past, present, and emerging, and I celebrate the diversity of the Aboriginal and Torres Strait Islanders peoples and their ongoing cultures and connections to the lands and waters of Australia. So, Alison, thanks for your question. You guys haven't registered for this, so I don't have your email's address other than just spamming everybody in the art of estate planning. So, what I just recommend is if you click on them, hopefully they'll be in your browser with the slides. You can just download. You should just be able to download them. On the top left, there's a little download arrow, and then you'll get them to your system. And then the rest is just to the public legislation. So sorry about that, but hopefully that works for you. Okay, let me check the time. All right, it is right on midday, and we've got a bunch of awesome people who've jumped on. So I will get started. Thank you so much for joining me. If you don't know me, I am Tara Lucke, founder of the Art of Estate Planning. And in this Power Hour, which is the old Facebook Live, I've migrated us over to Zoom instead of going live in the group to trial that new process. And it was just getting harder and harder to go live through Facebook. So we're calling it a power hour. So thank you for bearing with me as we trial this new system. So today we're talking about the new Trust Act from Queensland. So before we dive in, I just want to confirm the format for this new style. So it is not a webinar, it is a meeting. So put yourself on mute so that I don't have to hear you crunching your lunch or the dog in the background. Let's I'm very open to making this interactive and dynamic. So we've got the meeting chat. That's probably the best way to start initially, just putting things in the chat. You guys can all chat with each other as well. And then I will keep an eye on that, and then I'll sort of open it up to everybody if we've got a discussion going on, and we can unmute ourselves and come on screen and chat if you want to. If you've got any support issues or questions or anything, hello at theartofestateplanning.com.au is the best email address. So let's get started. And I'm assuming the tech, this sounds like the tech is all working fine, so I'm just going to go with that. So this session is just going to focus on what we need to know about the new trust legislation from an upfront estate planning perspective, focusing on testamentary trusts and family trusts. It's a big piece of legislation, right? I've printed it's a lot to get through, and it covers a lot of things. So I'm just going to focus it on my area of specialization, which is upfront estate planning. There's a lot in there about obviously orders from the court, charitable trusts, trustee duties, actions against trustees. So I'm not diving into that. I've been advised that the Law Society and Step Queensland are also planning on running events, and I'm sure they will also have a broader analysis as well. So this is just an introduction, I guess, or a bit of a teaser into the things that I've been thinking about. I also do just want to say, I am not professing to be an expert on this new piece of legislation. I really just put this training together because I realized I'm going to have to pay attention and, get my hands dirty going through it. So while I'm doing that, I might as well put together a summary and we can do it together, and share what I'm learning as we go. So I'm definitely not an expert. I've had no involvement in any of the consultation or development of this legislation. I'm just sort of learning it as we go. And I suppose what I'm sort of keeping in my mind is you can absolutely read a section and have an idea about how you think it works, but there's nothing as good as testing out how a new section works as to applying it to an actual factual scenario, which we obviously haven't done yet. So I think this is going to be a bit of a continuing discussion where as we start thinking about this scenario and how does it work, our understanding about gaps and nuances might evolve. So I'm absolutely prepared to say, watch this space. We might be having a few of these types of sessions. I also want to just say a huge thank you to Chelsea Baker and Karen Gaston. I doubt they're here, but just to acknowledge them because they put together a really good session for the Law Society on the Trust Bill last year. And that I obviously attended that, and that really assisted with my review as well. So a huge thank you to the work that they have already done for the estate planning community in Queensland. I've linked the legislation and the explanatory memorandum. Do read them. Don't just rely on my summary. I actually think having a hard copy of the Act is very worthwhile. If you're in a smaller firm where you don't have like a big printing resources, I'm at my home office. I just got mine printed from Officeworks and it was like $30 or something, and it's bound up. And now I think that's going to be, it's such an easy way to keep referencing it and to look at it off the screen. Last thing as well, this is not really about today's topic, but it's obviously very adjacent, is that the Queensland Property Law Act from 2023 starts on the 1st of August this year. And it obviously has a lot of changes in it, but the big one for trusts is that the perpetuity period is being extended from 80 years to 125 years. So obviously put that on your radar as well. Okay, so a little bit of background. Um, we've got the Trust Act from 1973. Nothing happened for like 50 years. And then in 2024, the Trust Bill was brought to legislation, brought to the legislature. It actually lapsed. And then this year we had the Trust Bill 2025, which has a few variations to the 2024. So don't just assume that the 2025 and 2024 legislation is exactly the same. There are some changes to it. So if did all the preparation work last year, just be prepared that there are updates. And we finally had the Trust Act 2025 assented to and passed in May. We don't know when it's going to start. To my knowledge, I've looked everywhere. So if you know more than me, please tell me. But the commencement of the Act is to be fixed by proclamation, and the proclamation hasn't been published and declared. So we don't know when it's going to start. Word on the street is that we should get a decent lead time, like hopefully a year or so, for us all to get familiar. So don't stress. I think if we can just start accustoming ourselves to the fact that there is going to be a change, and then we can get ready when the transition happens and we've got more certainty. But there are like one or two things to think about that you might want to start changing your practice now. Okay, so let's dive into it. Now, I just want to clarify when we're talking about the Trust Act, obviously it applies to trusts, family trusts, inter vivos trusts, testamentary trusts, but it also applies to this scenario of an estate. So basically, once, an estate being administered, once that administration phase is complete, then technically the personal representative starts holding the assets in the estate on trust for the beneficiaries until it's then transferred to the beneficiaries. So we sort of move from the estate to this bare fixed trust, technically, even without anyone really knowing or paying attention to that. And the reason is because, once the estate is fully administered but not distributed, those beneficiaries have become presently entitled. They have an indefeasible invested interest in the estate, even if they haven't actually been transferred the entitlement. So you'll see that this legislation actually covers that as well. And the new act makes it a little bit clearer. So let's just start at the very beginning in terms of the scope. It applies historically, so retrospectively, to trusts already in existence, even those established before the Act. It applies despite a contrary interest in the trust instrument, except to the extent the Act otherwise provides. So that's interesting. Some of the sections actually override the trust instrument, and others then a backup in the event that we don't want to rely on any power or there is no power in the trust deed. So it says the Act does not prevent a settlor conferring additional powers or those greater or expanded than what is under the Act. And yeah, so basically, we've just got this same interaction clarifying, what takes priority. So some you'll see as we go through, some actually take priority over the deed. Now, there's an expanded definition of trust. So that includes, implied, resulting, bare, or constructive trust, as well as the duties incidental to the office of a personal representative. So just that additional or clarifying that it also applies to deceased estates. We've also got a definition of trustee. Again, personal representative is included in there. So just no uncertainty. Because I think a lot of, lay people especially don't really think of just an estate as being governed by the Trust Act. They sort of stop at the Succession Act. And Section 17 specifically says, it applies to a trustee who is the personal representative of a deceased estate. Once the personal representative has completed the administration of the estate and then holds the estate assets in capacity as trustee. So our delineation between where the Succession Act stops and the Trust Act begins. We've also got an expanded definition of trust property. So nothing too controversial in here, but again, it just clarifies, the estate assets that are then held on trust as well. So just to make this, hammer this home, basically when the the estate is in the deceased administration stage, we've got the Succession Act governing it. And, if you use the Art of Estate Planning will precedents, that will be Part D and the powers and provisions in Part D of our precedents. Once the administration is finalized and the executor is deemed to now hold the assets on trust for the beneficiaries pending distribution, Part D still continues to apply, even if it is a testamentary trust will, but then we move over to the Trust Act as governing the management of that trust. So if we think more about expanding on that scenario where we've got like a basic will, simple will, or an intestacy where there are gifts to minors, this is how I think the workflow happens in my brain, at least. So, it goes into the legal personal representative. They hold the assets in the estate. They go through the administration process. It then goes to the legal personal representative is deemed to hold those assets on that bare trust until they make the distributions. And let's say under the distribution, you've got like 3 beneficiaries and 2 of them are adults and 1 of them is a minor, and they've named, someone to hold the assets for the minor. Then, we have the distribution and the minor's share of the estate is held on a new fixed trust by that new trustee. And then eventually, once that minor reaches majority, and the trust ends, or they call for it under Saunders and Vautier, then the trust ends and it goes to the ultimate beneficiary. So, this is where I would say, like, the Succession Act and Part D of our wills applies to the administration of the estate. And for those two separate bare or fixed trusts, we have the Trust Act applying. In the art of estate planning wills, it would be Part D, and or if you set up additional terms in the will, if it was a guardianship fund or something like that, but in the base case, just Part D. Let's now have a look at the testamentary trust scenario, and let's just say the whole estate is being gifted under the will to the testamentary trust. So we still sort of have, this process here where it goes from the estate to the trustee of under administration, and then the trustee holding the assets distribute it to the new trustee of the testamentary trust. And that's where we would have the Trust Act applying, but Part E, our additional terms that apply for the testamentary trust with the full trust terms in there. So hopefully that just gives a little bit of context about how the trust legislation fits into the time zone. So the purpose of the update, obviously it's 50 years old, so it's a bit out of date. So the main purpose is to, reduce known gaps and ambiguities, modernize the legislation and process in accordance with, inflation, but also society standards. Like, for instance, they've removed requirements about when a minor beneficiary gets married and things like that. That's no longer really reflected in society standards. And they've also just sort of codified a lot of sort of the common law principles. So one of the main things they've done is codified some of the common law duties into the legislation. So the 1973 Act didn't really provide any statutory duties of care. The new Act brings in these minimum statutory obligations. Now, they're not like detailed and prescriptive. They're more sort of broad and general, but it is now enshrined in the legislation. So I have got this is a dry kind of topic. So some of the sections I've put on the screen, I'm not going to go through all of these with you. I want you to just go and like read through them in your own time. And that's why you've got the notes. So you can go and have a look at which ones. But, Section 62 has this general duty to exercise care, diligence, and skill in administering the trust. Section 63 has a duty to act honestly and in good faith to further the purposes of the trust for the benefit of beneficiaries. So we're not learning anything new here, right? These are always the common law duties. We have had a bit of an expansion in terms of record keeping. So Section 64 does impose a duty now to keep accurate accounts and records for a minimum of 3 years after the termination of the trust. So that is new. And also they've sort of enshrined the right of beneficiaries to access the account. So Section 65 now imposes a duty on the trustee to make the accounts available for inspection by beneficiaries and to also provide copies within a reasonable period upon the beneficiary paying the reasonable costs of doing so. So we've also got some expanded powers in relation to investments, and it really goes through, again, have a look at this and you'll see it goes through and it really has the different standards set out in the legislation about the duty of care, and it compares a professional investor or someone who holds themselves out as having this special knowledge or experience in investing. And it holds them up to a particular standard, and then it has the standard for the layperson trustee as well. And then it says the trustee can invest in any investment other than an investment which the trust instrument expressly forbids. We've also got some replication of Section 23 and 24 from the old Act. And then Section 73 says the trustee must proactively review the performance of investments every 12 months. So if you're obviously advising trustees on how they manage and administer the trust and their duties, then this will be really important for you to get across. In terms of if you're just doing upfront estate planning, then it's sort of important to know, and these can be helpful to refer to clients in terms of giving them peace of mind and also letting them understand the gravity of the trust arrangement. So, sort of broad brush comments, and a lot of these are taken from the explanatory memorandum, which emphasizes these changes. So, the Act adopts the minimum statutory obligations rather than setting out detailed or prescriptive requirements. Yeah, it really emphasizes if you're in profession, business, or employment, managing the affairs of others, and as professional investors, that you have a much higher standard of care. So I think again, if you are taking on executor and trusteeship appointments, this is obviously something you have to be really across. If you've listened to my podcast episode about that, I actually avoid or recommend against um, lawyers taking on the role of executors and trustees. Um, Unless you have got a really established process in place and it's something that you're really set up to do, I don't think it's something you should do ad hoc where you feel bad for the client, especially, because of these requirements. Even if you think that you are just being the executor, you are also subject to this Trust Act requirements once the estate administration is completed. Now, that may actually be a very short time. And you may not, it really doesn't matter because you're basically administering it and distributing it right away. So you might be trustee for a day or a week, but just bearing in mind, that there is a very high standard on us and risk exposure. So that's the trustee duties, trustee powers. So we've refreshed and modernized our investment powers in part six. There's an allowing of delegation of trustee investment powers. There's a new section 75 about the ability to purchase or construct a residence for beneficiaries, which I'll put on the screen in a minute. Section 82 just confers the trustee all the powers of an absolute owner of trust property subject to the trustee's duties. So very broad powers there. Um, there's removal of the trustee expenditure $10,000 limit that was in the old act. And it just clarifies expenditure can be recouped or allocated from capital or income. So, Section 75, this is interesting because it actually applies despite any contrary intention in the trust deed. Where, yeah, so a trust instrument cannot forbid this section applying, basically, which is interesting. So now, like in the past, I've sort of always said we have to make sure that there's an express power in the trust instrument to allow the trustee to grant a right to occupy to the beneficiary. But now this is enshrined in the Trusts Act. It does say you need to consider the extent of the beneficiary's interest under the trust. You can under the old act, there was a similar power. This one is expanded to also say you can construct or build a residence. And subsection 5 here as well means the trustee can continue to hold on to the residence even if that beneficiary then goes into like aged care or retirement village. So have a good look at this one, section 75, and just have that up your sleeve. I think that's going to be handy to rely upon. And then 82, I'm just going to check. Yep, so 82 sub 1, the trustee has the power in relation to the trust property that an absolute owner would have. And then we've just got general powers, but we say a power conferred under section 1 other than these powers here can be excluded or modified by an express statement in the trust deed. So they're actually saying you can't take these out, or you can't override and say they're not available to the trustee, which I think is interesting, especially if we're trying to draft a customized like protective trust or something where we want the trustee to have really narrow powers, because, selling power to sell the trust property. If you've got a trust where you're putting in like a sentimental property that you don't want people to be able to sell, my reading of this is that you can't actually prevent that happening. I imagine you could you even put in a clause saying that it requires the consent of someone before the trustees exercise? I don't know if that actually would be allowed. So yeah, I think this is interesting, and I particularly this 82 too. I'll be really curious to see, as we dive deeper into how this works, how limiting it is. And yeah, Nikki, great question. 75. I think this does mean that it really is helpful when it comes to the principal place of residence (CGT) and land tax exemptions where a beneficiary is occupying the trust property. So previously we've sort of said, you need that power in the trust deed to allow to allow the trustee to pass a resolution to create the right. I think what that means is you still go through that same mechanism of the trustee passing a resolution, um, but they're sort of acknowledging it under what's in the trust deed or under Section 75. So I think that's quite helpful. If anyone has looked at 82 and has another opinion or really thought about how it's going to operate, let me know. Otherwise, I think, we all just sort of need to be mindful of this, including, is it applying retrospectively or not? So, yeah, that's one thing to have on notice. The next is the appropriation power. So, Division 3 of the Act modernizes the appropriation power, and it basically, so this is in addition to what you might have in the legislation. It's not in the trust deed. It's not overriding any powers you might put in the trust deed. It's something that you might rely upon if you don't have the powers you need in the trust deed. So it creates a statutory power for the trustee to appropriate the trust assets in satisfaction of a legacy or the beneficiary's share of the trust assets. So it's a similar process. There was already a similar section and division in the old Act. This one expands the notice requirements to 2 months instead of one, but also says it can be shortened or waived. It also brings in a process for when a beneficiary or interested person doesn't have legal capacity. So just being aware of that, we've got that up our sleeve now. The big one for us, I think, and that I feel has been the most radical change, is around trustee succession and the trustee requirements. So they've really gone hard at modernizing this, which so they should, because those old trust powers were really quite out of date. So I'm going to go through Section 19, 20, and 22, as well as some others. Now, the main thing is that it entrenches the role of appointor. So, under the old Act, it's acknowledged that there could be an appointor, but it used very general language like powers of a person who has powers of appointment. In the new Act, it just goes hard and uses the term appointor. So, some people use principal and guardian and appointor. So I feel like in, 10, 20 years time, we're all going to be using appointor, and we probably won't have this difference in language. So the Trusts Act has put its money on appointor. Now, it recognizes the role that there may be an appointor under the trust deed and as part of the trust arrangement. And it has this Section 18, which is just tying into the language in section 19, 20, and 22 about when an appointor can act, this is the process. When an appointor hasn't acted, this is the process. And they basically say the appointor has to exercise their power of appointment within a reasonable period, and otherwise, or if they're not able and willing to act. So it also then says if you've got two or more appointors, they will be deemed to be not willing and able to act if they can't reach agreement. So if they have to make joint or unanimous decision making, if they can't do that, if the deed says decisions can be made by a majority, if they can't reach a majority decision. So if they haven't exercised their power at all, if they're the sole appointor within a reasonable period, then they'll be deemed to be willing and able to act. So I've just got a big question mark here about what a reasonable period is. I haven't been able to find anywhere that says what that is. So I wonder if that's where we will be facing litigation around trying to get interpretation over what that is. If anyone has come across guidance about what a reasonable period is, please set me straight. But that's not been something that I've come across as being defined or any parameters around in the explanatory memorandum. Okay, so section 19, if there is an appointer for the trust, sorry, let me just read that again. Oh, yeah, yeah. So it's basically saying, okay, there's two mechanisms, whether if there is an appointer or if there's not an appointer. So if there is an appointer, then read the bits that apply to where the appointers act. And if not, skip those bits and, move on to the next section. So it's basically saying the trust deed mechanisms also take priority. So you can rely on this, but you can also, follow the process in the trust deed. So generally speaking, I think, with a fully fledged testamentary trust, you'd probably just use the mechanisms in the trust deed, right? Like they're still, I think, more comprehensive. It kind of depends on how old your deed is. Like we at the Art of Estate Planning just released in May a big update to our precedents, and one of the things was that we really overhauled the change of trustee, change of appointer, and the succession mechanisms and ability to appoint a successor and what takes priority and whether you've got a successor named in a deed of successor or a successor named in like the definitions and already hardwired in successors. So we overhauled all of that to really try and close out any gaps. So relying on those provisions, if you've got like an Art of Estate Planning testamentary trust deed, is the way to go because they're still more comprehensive than what's in here. But if you've got a really old deed, which really is silent on all of that, then this is really positive because we've got like some clear mechanisms here. So, yeah, it's just confirming that the trust deed can take priority. And then the next one, sub 3 here, if a will names a person as trustee of a trust created by the will and the person is dead, the provisions of this division that apply if a trustee is dead apply whether the person is named as a sole trustee or otherwise, and whether the death of the person happened before or after the death of the testator. So it's this one here I'm looking at, which is interesting. There's another section 36 in the Act which says where there's like joint trustees and a surviving and one of them dies, the surviving trustee can act alone. That's section 36. But here it seems to be saying that if it's a trust created by a will, that's not the case, and there will be scope for a replacement to come in. So that's curious. I just wonder if, that section 36 applies to like inter vivos family trusts, but not this not trust created by a will. Again, I think when we're drafting our testamentary trust and we particularly want to do like multiple layers, the first trustee is A, and then if A can't act, then B and C and so forth. I feel like that would be enough to override this section 19(3). But, we do have to be kind of very clear about that. Okay, so section 20 is basically our list of things that entitles us to replace the trustee. So, death, they just want to be retired, they declare that they want to be removed, refuses to act as trustee. I'm going to come back to this one, is unfit to act as trustee, is incapable due to impaired capacity, insolvent, disqualified from managing corporations. Um, so nothing sort of too controversial there. But if any of those events happen, then the following persons, so have a look at sub 3, the following persons may appoint one or more persons as trustees to replace the relevant trustee. So if there's an appointer, the appointer can. If there's no appointer or the appointer is not willing and able to act, which that refers back to section 18, which also includes if they haven't taken action within a reasonable time, then the continuing trustee is able to take and appoint the replacement trustee instead. So this is where I feel like it's unclear, like when is the cutoff for those continuing trustees to step in if there is an appointer, but the appointer hasn't taken the action yet. 21 talks about replacement of the last continuing trustee who is dead. So this is where there are no continuing trustees. So something happens in section 20, sub 1, and they're the last trustee. There's no appointer who's willing to act, and there's no continuing trustees. Then you refer to the mechanism under the trust deed. If all else fails, then it's the personal representative of the last trustee can appoint a replacement. Now, it's not defaulting and appointing the personal representative as the replacement. So if you're used to the art of estate planning precedents, we actually just put the personal representative in to the role. Here, it's like the personal representative gets the power of appointment. So they sort of become like a quasi-appointer for this limited scope. Then there's a bit of clarification about like with the personal representative. So, and I just confirm the Acts Interpretation Act defines personal representative as the executor or administrator of the individual's estate. And then here it just clarifies, if you've had like several people appointed as executor, but not all of them have been given the grant. Where's the exact language that it says? Have not proved the trustee's will, then it's only the people who proved the trustee's will and actually became the executors or administrators under the grant. And then, if there's more than one, they have to do that role jointly. So I think this is really positive in the event of death. We've got a clear pathway to follow, especially helpful for those older deeds. 22 deals with impaired capacity. Actually, and I should say, I'll just jump right down to the end. Where are we? So the act actually introduces a definition of capacity and impaired capacity to reflect what's in the Guardianship and Administrative Act. So that's helpful too as well. So, we've got some consistency there. I'll just jump back up to where I was, if I can find it. Okay, so then we've got a similar mechanism for the trustee losing capacity. as we have under the event of death. But so, it goes to the appointer. If there's no appointer, then the administrator or attorney gets the power of appointment. And just for clarity, it does allow the executor or the administrator of attorney to appoint themselves. They're not just automatically appointed by default. Um, yeah, so now we've got this new mechanism, and then we've also got a mechanism upon insolvency under administration. Oh, let me just check. I actually don't remember who gets this. Oh, sorry. I do remember the last continuing trustee. Yeah, okay. So the trustee who is the last one and becomes insolvent, they actually get to appoint their successor. And it says here it's a personal right that only of the last continuing trustee. So I interpreted that as meaning like the bank trustee in bankruptcy can't step in to exercise that power. So I don't know what the insolvency lawyers think of that, but that's our new mechanism. And then, so that all of those apply. So the power of the appointer to like remove them is really only applying if something happens in section 20. So dying, loses capacity, refuses to act, unfit, incapable of acting, insolvency, etc. So that's where those mechanisms tie in. Section 29 creates an ability for the appointer to change the trustee, um, but only if something happens under section 21 CDE. So basically, it applies sort of for these ones here. So it's more like, obviously, if the trustee is dead or incapacitated, then obviously that's clear the trustee can't act. Here, it's a little bit like the timeline can be a bit unclear. So it gives the trustee, sorry, the appointer, the ability to just boot out the trustee. But it doesn't, for instance, just give the appointer the ability to like unilaterally change the trustee without a reason or without cause, which most trustees do. They basically say, the appointer is ultimately in charge. If they don't like the trustee anymore, they can remove them. They don't have to have a reason. They just have a straightforward power to do so. Here, it has to be supported by a reason. One thing I'm a little bit like uncertain about, or that I think could be problematic is item D in section 20 about unfit to act as trustee. And if you are, an appointer and you just come along and remove the trustee on the basis that they're unfit, and could you end up in litigation arguing over whether they're fit or unfit? Now, I suppose this is somewhat helpful in that you don't have to apply to have the trustee removed. You can just remove them. But I still think, we're much better off having expansive powers under our trust instrument that don't actually require us to show cause. Um, yeah, and then section 36 is just this section which is saying if you had two or more initially and one dies, then the surviving or continuing trustees can continue. Now, interestingly, this only seems to apply on death. It doesn't deal with like incapacity or if they're removed for another reason. So I wonder if you could end up with a gap there. Now, there's still the same mechanisms about vesting of trust property in the public trustee, which I was initially thought that these sections sort of 20 to 23 overrode or avoided the need. But when I think about it, this is very similar to what's already in the old act. And I think what happens is when you've got a gap, so the old trustee is dead, say, or the original trustee is dead, and it takes a week to appoint a new trustee, and by the appointer or by the legal personal representative exercising their power of appointment, there has to be a legal owner of the trust property during that intervening period. And that under this section is the public trustee. So Section 40 then says once that new trustee is appointed, then the public trustee, you notify the public trustee and the assets of the trust or the trust property devolves from the public trustee into that new trustee. New trust. So I don't know if anyone's been through that actual process and what it is, but I think that's just to avoid there being no legal owner. Um, yeah. Yeah. And then this is so yeah, I think it's 38, 40, and 41 all sort of relate to each other just depending on how that new trustee was appointed, whether it was like the appointer or the exec legal personal representative or that type of thing. So, my comments on this, yep, trust deed overrides the Trust Act, and I really don't think this is any substitute for having comprehensive provisions in the trust deed, but these are definitely a very welcome modernization of what we're currently dealing with when we've got old deeds or those bare or fixed trusts that we just don't really have a lot of powers for. I think, yeah, really useful for those bare fixed trusts. I have some questions about what is a reasonable period and what is that going to mean? Maybe it's the you'll know it when you see it type test. Um, Interestingly, there's no power in here for a trustee to automatically name a successor. So we still have quite a reactionary process, especially, like that last trustee, or even if you've got joint trustees and you want to name someone to replace your vacancy, there's no express power to do that. You're sort of relying on the continuing trustee or the appointer or your personal representative fixing it up after the event has happened. Um, One thing that was in the old deed, which is not here, is there used to be an automatic removal of a trustee if the trustee was out of the jurisdiction for more than a year without delegating. So that's no longer in there in that list of items in section 20. Um, Also positively, I think, is we have the acknowledgement of the appointer role. So as I mentioned, I really think that we'll probably all just move towards being really consistent with that terminology now. There's nothing in here about the succession of the appointer role. So, yeah, if you do have an appointer and they die, there's no like plan. So you'll be relying on the trust deed for that again. Um, Also, this is really only dealing with those events where the trustee is removed. It's not allowing the appointer to just remove the trustee without cause because they want to. So I think a lot of us will still be just relying on the trust deed, but a very welcome modernization, I would say. The next thing is we've got some restrictions on who can be appointed as a trustee. So we went over this in the TT Precedents Club a few weeks ago. So thank you to Nikki Goff, sorry, I don't know how to pronounce your last name, for bringing this to our attention. But I just wanted to mention it to everybody. And I think it's probably the most radical change. I'm just going to check how I'm going for time. So I'll speed along because we've got to finish on the hour. But basically, Section 13 talks about who can't be appointed as a trustee. So obviously someone who's insolvent, or a insolvent company, a person disqualified, but most specifically a child. So um, a child cannot become the trustee of a trust. And I've just got some sections here. You've got all these in your notes, but when I first looked at this, I thought, well, that's fine. You have to be 18. But it actually goes further than that and says that a minor cannot be named to become a trustee upon reaching majority. So there was discussion about this in the parliamentary report, saying that the QLRC final report on the legislation actually suggested that you should be able to name a minor but have their appointment take effect once they reached a certain age or majority. But despite that, um, Section 13 actually says they can't be appointed at all. And that was because of these difficulties with the minimum number of trustees. So there's just, I've got some sections from the explanatory memorandum here, which like expressly states, you can't have the appointment of a child conditional on them attaining majority anymore. So that could be something that some of us have to pay attention to. I think obviously moving forward, don't put that into your wills. Um, oh, actually, and I didn't hide this out, but it's it doesn't say subject to contrary intention in the trust deed. So I think it's not something we can override with the trust deed. So I think the position is that we shouldn't be naming as trustees minors who, when they turn 25, they become the trustee. Now, yeah, Lydia, what about when we put from X date, they become the initial trustee? I don't know. Like, is that's almost like just a succession plan, isn't it? Um, Rather than as, a conditional appointment. So could it be like if you did it in a deed of successor, would it be okay? I will say there's nothing in here preventing them being an appointor. So you could probably still find a pathway to have the minor become the appointor, and then they can exercise their power of appointment to change it. Um, Matt, it does say here at item 4, this section does not apply in relation to the appointment of a personal representative. So it seems like executors, it's okay, but not for what. So maybe it's like if they can be the executor, but if they transition to holding the assets on trust under the estate, they are no longer a trustee. I don't know. I actually am a little bit like muddled about this in terms of how it's going to work in practice. They actually do this in the ACT already. They have copied what they do in the ACT. So it's not completely new, but it is definitely a new thing for us. So I think moving forward for your wills, don't do it or just do it for the appointer role, which, like New South Wales lawyers, we're already kind of doing that. We're just putting in like the succession plan in the appointer role because their change of trustee exemption requires new and continuing trustees to be excluded as beneficiaries. So you don't normally put your family, you don't want them to be a trustee and excluded as a beneficiary if they are intended to benefit. So I think we just do it for appointers. If you've got old wills, um, they may need to be considered. Like I don't actually know what happens if like you put it in the old will before this legislation or before the testator dies, they are actually an adult. I think they should be able to continue to act, but I don't know actually. So definitely happy to keep talking about this. But we're all on notice now. Whether you want to like include some reinstatement provision, is that I actually have a question mark against that because is it kind of what you're suggesting, Lydia? Yeah, so I feel like we might just have to sort of muddle our way through applying this new section based on what we see in the like in case studies and keep applying it that way. But that's probably the most radical change. Number of trustees. I'm just going to zoom through these because we've got a few minutes left. But the number of trustees is sort of very similar, sets the limit at four, but you can apply to the court to have more than four. You used to be able to do that, but you applied directly to the minister. So that's very similar. We've got this requirement, which is basically the same as the old section 12 sub 2 sub C, where you can have one trustee that is like a company. Um, or you needed two individuals unless the trust was established with only one individual as the trustee or expressly overrode this section. So 27 is a mirror of that essentially. Um, the problem with the old 12(2)(c and the same with this 27 is you can technically, if you started with two individual trustees and they retire and you replace them with one individual trustee and your deed doesn't override this section, then what happens? You can still, that one replacement individual trustee is still a valid trustee, but the retiring trustees are not discharged from being liable for the debts of the trust. So obviously, if you're not a trustee anymore, you want to be discharged from liability and off the hook. So that's the consequence. So it doesn't actually change anything. We've just got a new replacement of that section. Um, Again, there's no limit on appointors. So under this legislation, it acknowledges the role of appointor and authorizes them, in terms of appointing replacements, but it really goes no further in terms of succession of appointors, limit on the number of appointers, that type of thing. So, and that eligibility criteria, now we've got that issue with the child. There's also delegation, a refresher of the ability for the trustee to delegate. Again, this doesn't replace what's in the trust legislation. Sorry, this doesn't replace what's in the trust deed. So it's just pick, is the trust deed delegation power better or is the Trust Act delegation power better? And if you have a very bare bones kind of trust, this is kind of what you've got. So very kind of similar. It limits the ability to delegate for 12 months at a time. And it also includes this new requirement about notice. So you have to give notice to the co-trustees and also, sorry, I think section 31 is what I'm trying to highlight. When you do a change of trustee, then you have to notify any delegate as well. So that's a new statutory requirement that wasn't in there. And this is only moving forward after commencement of this new legislation. So I think, we would still definitely prefer what's in our trust deed over what's in this, the 12-year restriction. It also doesn't really allow for delegation on incapacity or just general succession planning. It's more for out of the jurisdiction delegation. So it's still very narrow compared to what we have been able to do under the will drafting and trust drafting. Oh, I won't go into all of that. Only just to say, the actual ability to delegate is under general law, and historically, it's been very limited by the legislative delegation power. So usually, you can delegate under general law, under the legislation, and then an express authorization in the trust deed. So I still think this combination of the general law power and the express power in the trust deed is the winning formula where you can. Section 121 is sort of like that Saunders and Vautier requirement that absolutely entitled beneficiaries can notify the trustee that they're revoking their powers. So it's still confirming that, but it also now has a process for when one of the beneficiaries lacks capacity that was previously not clear. Um, There's this interesting one about disclaimer of trust. So if a person is appointed as both executor and trustee and they renounce probate or don't apply for being for probate, then it is taken to be a disclaimer by the person of the trust of the will. I actually don't have much experience with this section, so I don't know if that means they disclaim their entitlements under the will or they just are disclaiming the ability to be a trustee under the will. So I just wanted to bring this to your attention if you are familiar with it and are very open to hearing from anyone who has experience with this a similar type of section under the old Act. There's also sort of clarification here about, the timing of getting the grant. We're actually right on time, so I won't go into that. I'll just scoot off really quickly through. There's some expanded powers for income and maintenance for minors. So it also means that you can make allocation for maintenance of minors, even where their interest is vested, contingent, future, absolute interest, or liable to be divested. It removes this requirement that a beneficiary receives their accumulated income when they marry. There's an expansion of their capital advancement power from $2,000 to $100,000 or no more than 50% of the capital, whichever is greater. There's also trustee remuneration. So we're practically replicating the existing provisions, but the court has power under Section 161 to reduce the fees if they're considered excessive. And then we've got that capacity definition, which we touched on. So that's it. We've sort of gone right on the hour. Thank you for bearing with me. I know that was very information heavy and a lot to digest. I hope the slides are helpful. I think this is definitely going to be like a watch this space. As you can see, I haven't totally wrapped my head around how some of these new mechanisms might work in practice. So I'm sure they're going to keep coming up in the TT Precedents Club where we're constantly talking about them and applying them. So we might have another session closer to the commencement when we find out what that is, or just, very open to just having a general chat about it as well. But yeah, that's sort of where I'm at in terms of my journey of making my way through this. I think really the main takeout is really quality trust terms for our trusts are still really important. I think the trust legislation is really just a backup still. And for people doing will drafting, just pay attention to the limitation on children now being able to be, or the restriction on children being able to have a contingent appointment as trustee. Thank you so much, everybody. I'm happy to keep the conversation going. If you've got more questions, let's post them in the Art of Estate Planning Facebook group. I've got to run to the TT Precedents Club hot seat. If you're in the TT Precedents Club, we can also keep the conversation going there as well. And I will see you next month. Thank you so much.